While we're working on this, I'm going to go ahead and just introduce myself real quick. I'm Rachel Sterling, and I am the COVID-19 eviction response coordinator for Homeline. I am facilitating this meeting today. If you've been to our previous meetings, you may recognize me, but usually Eric Hauge is in charge, our director. So, but in general, just a little bit about what we are doing here is we are hosting webinars about weekly now through March of 2020 through now. We just started these back up again. The Minnesota Eviction Moratorium Phaseout webinar series is something that we use to just help folks understand what is happening with the phase outs and what is happening with updates in landlord tenant law. So today our guest speakers are going to be Laura Jelinek and Colleen Walburn, who will talk about some of non-phase out law updates that we have regarding emotional support animals and other reasonable accommodation requests such as that. And then we will also have Sam Parmakar, who is going to be speaking about a law that is going to go into effect September 1st regarding prorated rent on short-term or leases that end before the end of the month. But before we go into that, let me just briefly get you to a place so that our other speaker, Samuel Spade, who is the housing attorney and research director, can discuss a little bit about what the phase out is, just give a quick overview. I do see that someone is asking a question in the chat, which is an excellent question, Jack, of can questions be submitted in the chat? Please use the Q&A function that is at the bottom of your Zoom screen. Things get lost in the chat. I will be posting things in there throughout. And if there are questions, they may get lost, and then I will look through everything and it will I'll feel bad that I lost your question. So if you can post it in the Q&A, I will see it. We will get to it as soon as we can. At the end, we'll have a Q&A session. So hopefully we will be able to answer as many questions as come through. We'd love it if you have questions specifically about what our panelists are talking about today. So the new statutes that are, one of them is already in effect and they'll go into that. And then the one that's coming up in September 1st of 2021. But briefly, just quickly about ourselves. So Homeline is a statewide nonprofit organization, and we provide legal, educational, and advocacy services for free for Minnesota tenants. And we've been doing that for working on almost 30 years now. Very, very coming up. Most of our assistance is done through our hotline, which the number is on the screen here. We do offer our services in 4 languages, Hmong, Somali, English, and Spanish, as well as an email and attorney function. If you go to our website, homelinemn.org, you can click on the email and attorney option and ask your question that way if that's your preference. And so, all right, I see that, Colleen, were you able to join?
I am here. Hello.
Hey, I am glad that you have been able to join. I apologize for the technical issues.
No.
All right, so perfect. So then Colleen will be one of our panelists as well, who I will introduce briefly once we get to their section of the presentation. But if you've got questions, again, I'm going to reiterate, please put them in the Q&A that you can find at the bottom of your screen. We did get some pre-submitted questions as well, which we'll be going over briefly. If you have any other questions, though, again, specifically for our panelists today, it would be best to put them into the Q&A, and we will have a Q&A session at the end of the presentations. If you have questions or just want to get some more research or dig into the eviction moratorium phase out, Homeline does have a couple of web pages that have that information. We have the schedule for these webinars. We do have recordings of the previous webinars, such as last week we did one on the Zero Balance Project, which is a rental assistance program specifically for landlords. And the week before that, we did a Rent Help MN Q&A session that was very informative. So, and then upcoming webinars that we have planned currently for August, the remainder of the month, is next week we'll have attorney Larry McDonough. Will just give us a comprehensive overview of the phase out and also some pointers on litigating eviction actions. We will be applying for 1.5 general CLE credits for that. We'll also on August 25th, we will have Assistant Attorney General Catherine Kelly, who is going to just give some overview of what their office was doing as part of the enforcement of the Minnesota executive orders with the focus on the eviction moratorium for eviction suspensions and what they're planning on doing with landlord-tenant legal issues going forward. That will also be applying for 1.5 general CLE credits. And because I know I will get the question, we are also applying for 1.5 CLE credits for today's webinar as well. So once we get that approval, we will send out the link with the number that you can go and then put in for your CLE credits. So just in case you are unaware, if you are behind on rent because of COVID, there are resources available for tenants. Renthelpmn.org or calling 211 will help if you are a tenant. If you are a landlord, there is the Zero Balance Project that if you are a landlord specifically in Dakota, Hennepin, or Ramsey County, you can apply for emergency rental assistance through that. And then we will dive right into the overview of the eviction moratorium phase outs, a little bit about the CDC moratorium extension, and then we will dive right into the meat of our presentation today. The reason you all are here, the updates and overviews of the new statutes that will impact the landlord-tenant law here in Minnesota. So without further ado, I'm going to take a breather and introduce Samuel Spade, who is a housing attorney and research director here at Homeline.
Hello. As Rachel said, my name is Samuel Spade. I'm one of the staff attorneys here at Homeline. I'm going to be talking about the basic state of lease terminations and evictions right now under state law. I'm going to go through it pretty quickly because we have a lot of other things to talk about, and we've also covered it both in past webinars and, as Rachel noted, we're going to be covering it pretty extensively in an upcoming webinar next week. So the first thing that affects lease terminations and evictions right now is Executive Order 20-79, and that might be a little bit surprising because it was made null and void back in June, on June 30th. That said, though, it included an exception that is not included in the new session law, which is what I'm going to talk about next. And that exception was the ability to give notices to vacate if family members needed to move in. Now, those notices to vacate needed to be valid notices, otherwise valid notices under the lease. But it is possible that notices, especially if they were 2-month notices, notices would have been given in June that would be coming effective, in August under this exception. We're not sure how courts will handle this. The executive order is null and void now. We don't know if that means courts are going to reject those notices and say, even though they were valid when given, they're not valid and can't be enforced now under the new law, or if the courts are going to allow them to go forward. Obviously, we expect tenants to argue that those notices will be invalid, and we expect landlords to argue that they are not invalid. So far, the only case I know on this The notice was given and the case was filed in June, so before the session law took effect. And the landlord won in that case. It was heard in July, but it was filed in June. I'm sure that there are cases out there, maybe I'm just unaware of them, but this is still a little bit in play for that reason. But moving on to the session law, we have a couple different phases. The first phase started when it went into effect on June 30th. It allowed landlords to file if the tenants were seriously endangering either other people or the property, if they were committing certain types of crimes, only those crimes listed in 504B.171. And it also allowed landlords to terminate or non-renew leases for a material lease breach. Not file an eviction for that, but just giving notice to vacate for it. The other thing landlords could file evictions for back on June 30th were tenants who were eligible for rental assistance and were not seeking it, whether that was because they were refusing to apply or preventing the owner from applying or failing to provide proof, etc. They were basically standing in the way of financial assistance. This exception is only for people though who were eligible for rental assistance. If they were not eligible, that's a different category, which we'll talk about in a moment. The next phase was July 14th. This didn't change too much, but it did allow landlords to file evictions for material lease violations. And so that's the phase that we're currently in. Well, the first two phases, these add up, but those phase we're currently in. However, phase 3 is effective August 13th, which is in just a few days now. And that will allow landlords to terminate or non-renew leases for tenants who are behind on rent and ineligible for COVID-19 assistance. Again, this is in contrast to what was allowed on June 30th for tenants who were eligible for rental assistance and were refusing to apply or try to get it. And if this is not evictions yet, this is only notices to vacate. However, the next phase, phase 4, on September 12th, allows landlords to also file evictions for tenants or against tenants who are behind on rent and ineligible. Again, this is behind on rent and ineligible. So by September 12th, evictions for non-payments will be allowed against tenants who are behind on rent if they are either ineligible for financial assistance or are eligible but are not applying for financial assistance. Phase 5 on October 12th is when pretty much all of the off-ramp protections end and we go back to normal, for better or worse. Landlords will be allowed to give notices to vacate for any of the normal reasons. They'll be allowed to file evictions for any of the normal reasons, with the one exception of tenants who are eligible and have applied for financial assistance and have that financial assistance application pending. They're protected until phase 6 ends, which is June 1st, 2022. And I'll talk about this a little bit more in just a moment. But the next thing to talk about under the current session law is, and that's the section we're in right now. I forgot about that. But the next thing to talk about under the session law is the notice requirement for non-payment of rent cases. So certain non-payment of rent cases are allowed right now. Again, those for tenants who are eligible but are not applying. And in September, there will be more cases allowed for non-payment of rent. If a landlord is going to file an eviction for that, they have to give a 15-day notice. That notice has to state that the eviction moratorium or the 2789 moratorium has ended. The tenant can be evicted, has to state the total amount of rent due, and provide some basic information about where to get rental assistance. If the landlord does not give proper notice, the court can, at a minimum, use their discretion and stay the eviction until that is sufficient, or until the landlord gives sufficient notice. However, if the landlord doesn't even have substantial compliance with the notice requirement, then it is possible the courts could also dismiss the case. I don't think we've seen very much of this yet, but that is possible. And my guess is when we get to the next phase, or sorry, I guess 2 phases from now in September, when you can file evictions for ineligible non-payment cases, we're going to see more of this becoming relevant. And then we have the final thing under the session law, which is the final holdover period, or sorry, safe harbor period for tenants who have applied for rental assistance. If a tenant has applied for rental assistance with one of the appropriate places, mostly Rent Help MN and the Zero Balance Project, in those cases, the tenant is protected, assuming the only issue is non-payment, the tenant is protected until June 1st, 2022. So it's still a long ways away. And I wish this wasn't the case, but it may even be necessary for it to be that long, because we're talking with tenants still who have applied in May and still have not received financial assistance. And so this protection will last. It's very important to be aware of for both tenants and landlords. But if they're eligible, they've applied and that application is pending, they're protected, and they'll continue to be protected for a pretty long time. That pretty much covers the session law, but there's also the CARES Act to talk about. And this may surprise people as well, because it ended in 2020, so over a full year ago now. However, there is a 30-day notice requirement in that law that didn't have an end date or a sunset date. It only applies to certain rentals, but most federal subsidies, anything, for example, covered by VAWA, it applies to, and certain federally backed mortgages, it applies to rentals where the rental has a federally backed mortgage, or the owner does for that rental. The 30-day notice requirement is still out there in theory. We're not exactly sure when this will change, but we know that people across the country are still seeing it as a requirement in their courts, and certainly Ramsey, the last time we checked, was still requiring it in their eviction court case as well. So something to be aware of, again, for both landlords and tenants. And I think that's it for my section, Rachel.
That is correct. Thank you so much, Samuel. I'm going to briefly cover the CDC federal moratorium on evictions. So we got a little bit of a surprise last week during our webinar. The day before we did our webinar, the CDC decided to basically extend out the federal moratorium that they'd had in place since late 2020. And it's a little bit different than the original format. There are a couple of things that make it apply more narrowly than it did before. So basically, instead of being applicable nationwide, it's only going to apply to countries, or excuse me, counties that are experiencing substantial and high levels of community transmission of COVID-19. And that is something that's a designation that the CDC has based on positive tests that are being tracked, and the hospitalizations. So they track that on a week-to-week basis. And so if the county is experiencing a substantial or high level of community transmission of COVID-19, then they would be covered under the CDC federal moratorium. I will have, the next slide is a map of Minnesota that shows the current levels by county. So we'll get to that in a second. The CDC moratorium only prevents evictions for non-payment of rent. And so it still defers to stronger local protections, so including any state moratoriums. So at this point, Minnesota's off-ramp or phase-out, whatever you want to call it, is still broader in scope than the CDC moratorium. And so it doesn't really do much right at this moment. The point that it might come into play here is that phase that Samuel was talking about that happens on September 12th, when landlords can start filing evictions for tenants who are behind on rent and ineligible for the federal COVID-19 eviction rental assistance programs. Our phase out language is much narrower there than the CDC moratorium is, because the CDC says that a tenant is eligible for protections so long as they are applying for any government rent assistance. And so there are many more programs out there than just the like Rent Help MN or the Zero Balance Project, or the there's one I think that's just starting up in Ramsey County, emergency rental assistance, that is a federally funded program. But that's what the Minnesota phase out limits for eligibility. And there are certainly other government emergency assistance, other rental assistance programs that a tenant may be eligible for them, but maybe not for Rent Help MN, and so would then be covered by the CDC moratorium at that point. However, the CDC moratorium is only in effect until October 3rd. And so realistically, that span between September 12th and October 3rd is just over 2 weeks. So it's not, there are protections, but the actual impact may be limited. There are also other things to consider, such as court challenges. There were several challenges to the original CDC moratorium that was in place. And basically the day after this one was reinstated, the Alabama Association of Realtors, who was the same group who had challenged the previous iteration that had gone up to the Supreme Court of the United States, they basically reinstated their challenge right away for that. So we'll see what happens with that. That just happened last week, of course. So we don't really have any updates on that besides that challenge was filed. So as promised, here is the map of the state as of Monday, August 9th. So this was the transmission rates. If any of you were looking at this map last week, you will see that a couple of the counties that had been in blue, the low level of transmissions, have now gone to yellow, moderate levels of transmissions. But basically, the thing to note is that these are flexible rates. Like, so if a county falls below that substantial or high level of rate of transmission, then they would not be covered under the CDC moratorium. If they move up into that high or substantial level of transmission, then they would then be covered by the CDC moratorium. So it is something that the website that I have listed here on the slide is where anyone can go to see what either your county, what level your county is in, or the state as a whole, or the country as a whole. So that's where this coverage level decision is coming from. And just here's our timeline again, and the CDC moratorium effective, when it actually impacts Minnesota renters is it ends right smack dab in the middle of when phase 4 and phase 5 happen. That's when the CDC moratorium protections at this point go away. And so again, we have all of this stuff going until September, through 4. We have things going through October 12th. So again, the CDC moratorium really has an impact for about a couple of weeks at the end of September, potentially. So that is, I know we had some questions about the CDC moratorium. I will go ahead and turn it over now to Laura and Colleen. So Laura, excuse me. Sorry. So Laura Jelinek is an attorney with the Housing Equality Law Project at the Southern Minnesota Regional Legal Services, otherwise known as SMERLS. And then Colleen Walburn, which I'm hoping I'm pronouncing right, is an attorney with the Housing Discrimination Law Project with Minnesota Legal Aid. And they are going to be discussing the rights of tenants with service and support animals, as there is a new statute that has just come into law effective on August 1st. So thank you, Lauren Colleen, for being here, and take it away.
Thanks so much for having us. I apologize for participating without video due to a technical issue, but I am really happy to be speaking with everybody today. And I think Laura is going to start us off by talking about the overview of our presentation.
Yep. Hi, everyone. So first, we're going to give you a little background of fair housing law, let you know, remind you what's out there. And then we're going to talk about reasonable accommodations in housing law, fair housing law. And then we're going to talk about the new statute, 504B.113. And then we developed a couple of example scenarios that we were going to run by you to get your thoughts on, or get our thoughts on, depending on, it looks like our audience has grown exponentially. So perhaps we'll chat about the scenarios to make it easier. So Colleen's going to start with the fair housing background.
I really appreciate having the chance to talk about fair housing issues and appreciate all the interest in the audience. Today, we are going to be focusing on provisions found in the Federal Fair Housing Act and the Minnesota Human Rights Act. And our focus today is specifically on rental housing because much of our practice is related to providing free legal services to tenants with low income who face barriers to accessing and retaining rental housing. But both the Fair Housing Act and the Minnesota Human Rights Act have broad coverage for other areas that apply beyond rental housing. And so those would include areas such as home purchasing, including the services of realtors, lending practices, for example, and advertising of housing would also be covered by the Fair Housing Act and the Minnesota Human Rights Act. As we work in our practice, other civil rights laws come into play. For instance, cases where we advise tenants might involve advice about the Violence Against Women Act application in the rental housing context. In other contexts, Title VI protections to have meaningful language access in public and subsidized rental housing, for example. And then also the Americans with Disabilities Act is also applicable at times, but our focus today is really on the fair housing provisions of the federal law and the Minnesota Human Rights Act, as well as new Minnesota statute 504B.113. As everyone in this call knows, certainly other landlord-tenant laws may apply. For instance, I just mentioned that we do advise tenants on rights under the Violence Against Women Act, and as part of that, we may advise tenants on protections related to domestic violence under state landlord-tenant law as one example in which there is an overlap between landlord-tenant law and other civil rights law protections. And then finally, there may be pertinent local ordinances that could be taken into consideration when advising tenants on fair housing issues, including advising tenants on issues related to service and support animals, specifically if the city has adopted a fair housing or a civil rights ordinance. And so that's always helpful to take a look at. So that's sort of the fair housing, the starting point for how we'll talk about background today before taking a deeper dive into the new statute that is just been enacted. So we can go to the next slide. Thank you. And so these are the areas that are protected classes under the federal fair housing law: race, national origin, religion, sex, familial status, color, and disability. And I would mention that in providing protection against discrimination on the basis of sex, that would include prohibitions on sexual harassment in housing. And it would also include protections against any discrimination based on sexual orientation or gender identity pursuant to an executive order that was issued by President Biden. One other note I would make on the protected classes is that the protection for familial status, which refers to the presence of minor children under the age of 18 in the household is also very broadly defined in the Fair Housing Act. And so it may include a household where someone is in the process of securing custody of a child, or lives with the child pursuant to a written agreement with a parent of the child, for instance. And so one note for people who don't regularly analyze and interpret the Fair Housing Act would be the broad definition of familial status protection under the Act. And our state Human Rights Act adds several additional protected classes. So that would be on the next slide.
Sorry.
Oh, no, thanks. And you can see these listed here. I would say all of these are relevant to our work in advising tenants. And we advise tenants on these protected classes on a regular basis. I would say that in terms of understanding the protection of status with regard to public assistance, I would offer one example that arises in my work regularly would be if a landlord says that they will not rent to a tenant because the tenant plans to pay for the security deposit using emergency assistance from the county. Then that would raise a concern about illegal discrimination based on public assistance. Obviously, there are a wide range of other public assistance programs as well. Thank you. This slide describes a few of the areas of prohibited conduct under both the Federal Fair Housing Act and our state Human Rights Act. Oh, thank you for the note. Okay. Please let me know if there's improvement or lack of improvement on the audio. I'd like to be able to communicate effectively today. Okay, and so we often think of fair housing as making it illegal to refuse to rent to someone. But in terms of different terms and conditions, that would cover a wide range of treatment by a housing provider, which could include charging a different rent amount, or what we call steering or directing someone to a certain property within the apartment complex or a certain floor within a building, for instance. In other words, limiting housing choice based on a protected class, and may also go along with that, steering to a building within a complex that doesn't get the same services in terms of prompt repairs of essential functions in the apartment, whether that's plumbing or heat or kitchen facilities and so forth. And so steering and the failure to make adequate repairs might go hand in hand. Those are some examples of different terms and conditions of rental that might be violations of the Fair Housing Act. What would also potentially violate the Fair Housing Act would be if a landlord creates a hostile housing environment based on any of the protected classes that were discussed in the prior slides, where either the landlord or an agent or even a tenant might engage in a pattern of severe and pervasive harassment, for instance, based on a protected class status that would give rise to an argument that this was in fact a hostile housing environment. And so this environment was being maintained in violation of these civil rights laws. And then both the federal law and the state law prohibit any sort of retaliation or reprisal, interference, or coercion for someone asserting the right to live free from discrimination in housing. One misconception that I come across at times is that The Fair Housing Act only applies to, for example, public housing or subsidized housing, but in fact, the Fair Housing Act and the Minnesota Human Rights Act cover nearly every type of rental housing that we have in our rental markets, with very, very few exceptions. And the Fair Housing Act has been found to apply to settings such as emergency shelters and dormitories at universities. And so as a general rule, the Fair Housing Act and the Minnesota Human Rights Act apply to most properties in which tenants would be living. And now we're going to turn from the general background on fair housing law to a conversation more specifically about reasonable accommodations of disability in rental housing. And so we'll start off by talking about what is a reasonable accommodation of disability. And generally it means a waiver or a relaxation or an adjustment in the landlord's practices, whether that be the lease, the resident handbook, or the regular business practices, if that change is necessary to ensure that an individual with a disability can use and enjoy the housing. And so some examples of reasonable accommodations would include, for instance, a tenant asking to not be charged a late fee, even if the lease said the landlord could charge a late fee, for example, after the third day of the month. If the reason that the tenant needed to pay after that date was because that's the date when the tenant receives the tenant's check from Social Security because of the tenant's disability. So requesting to be able to pay rent late, because that's when the SSI check arrives, would be an example of a request for a reasonable accommodation of disability. We'd be asking for a waiver of the application of a late fee in that particular circumstance. Another example might be if someone was applying to live in rental housing and could qualify financially with the use of a cosigner. And so asked the landlord to accommodate the fact that on perhaps their SSI income, they might not qualify, but with the income of a cosigner, they could financially qualify for the housing. Could the landlord adjust or make a waiver to any policy against cosigners in this particular case because it's necessary for this individual with a disability to be able to be approved for the rental housing? Another example might be if someone, for instance, in public or subsidized housing, needed to have a live-in aide to provide services in the home, and in order to have a live-in aide, needed to be allocated an extra bedroom for use by that live-in aide. That might be a reasonable accommodation where we would advise a tenant. And then another example I would mention is with respect to communications. It may be necessary for an individual with a disability to communicate with the assistance of a social worker or with a social worker at meetings as one example, or in writing as opposed to other means of communication. So those might be instances where we would advocate that that tenant's unique needs would be met by the landlord despite any landlord policies that might be typically implemented. I think we'll move on to the, let's see, the next slide. It talks about how disability is defined when we're talking about reasonable accommodations of disability. And I think this slide is important because sometimes we'll encounter a situation where, for instance, a housing provider will mistakenly be applying the definition of disability that might be found in another federal law. For example, the definition of disability that you might come across when someone is being evaluated for eligibility to receive Social Security payments, for example. And in fact, the Fair Housing Act and the Minnesota Human Rights Act have their own definitions of disability. And these definitions are nearly identical, as you can see from the text on the slide here. A physical or mental impairment, which substantially limits one or more major life activities. And then the MHRA modifies that to state materially limits one or more major life activities. And so the definitions of disability are specific to fair housing laws, and they are very similar at the federal and state statutory levels, both very similar. And so if we're advising a tenant as to whether they are a person with a disability as defined under the Minnesota Human Rights Act and the Federal Fair Housing Act, and the question is asked, what does this mean, major life activity? How do we understand that terminology as it is used in the definition of disability? And so as this slide spells out, there are many examples, and these are just examples provided in the regulations promulgated under the Fair Housing Act. And so, for instance, these would include caring for oneself, manual tasks, seeing, speaking, breathing, learning, and working. But certainly cases that have been litigated have had other major life activities identified in them. And so there are, this is not an exhaustive list of major life activities. And so these are the general elements of what would make up a reasonable accommodation request in housing as a general matter. And thinking back to those examples I provided in terms of not being charged a late fee for rent, or having a co-signer, or maybe having a live-in aid. Generally speaking, what we would do is we would describe to the housing provider what the connection or nexus is between the individual's disability and the request that they're making, and then explain why this is needed in order for the individual to either be approved for rental housing, or to keep their apartment, or to not have to face the termination of tenancy or the eviction through a court. And so that's how we would demonstrate the necessity. And then the final element that you'll find in the decision from the court in Huberty is that the request that we're asking for is possible for the housing provider to implement. And so in talking about whether the accommodation that's being requested is possible to implement, one thing that we would evaluate is whether any of the sort of defenses that a landlord might argue to a reasonable accommodation might require some evaluation. And so what HUD and the Department of Justice, who are the federal agencies charged with enforcing the Fair Housing Act, have said in their guidance, and this obviously comes on the heels of decisions reflecting this, is that a landlord might argue a request is not reasonable if it is administratively burdened and too costly, such that it is in fact an undue administrative and financial burden. A second argument that a housing provider might make is that the housing provider cannot grant this particular request because it would actually constitute a fundamental alteration of the way that that housing provider does business. And so one example of that would be There was an example where, for instance, a tenant had a support animal and was unable to pick up after the dog. And the landlord had tried to arrange alternative approaches for the tenant to be able to pick up after the dog. And the tenant had asked, could the landlord instead pick up after the dog? And the landlord said that that wasn't a regular part of the landlord's business operations. And so they didn't feel that that request was reasonable. And then finally, an argument that a landlord or housing provider might make in saying that a request is not reasonable is that it would pose a direct threat to health and safety, for example, of other tenants or employees of the property management. And on this third argument that might be made by a housing provider in response to a reasonable accommodation request, it's really important to note that both case law and the guidance from HUD and the Department of Justice talk about the fact that you have to give consideration to whether there might be any modifications or any sort of steps that could be taken to eliminate or effectively mitigate a possible direct threat before conclusively determining that this reasonable accommodation does not have to be granted based on direct threat. And so there needs to be a consideration of whether there might be steps that could be taken to mitigate a possible threat. If a housing provider denies a reasonable accommodation request, a tenant does have options for enforcement. I would note that the timelines for taking action on fair housing concerns, both under the Fair Housing Act and the Minnesota Human Rights Act, the timelines are short. And so it's important to alert tenants that you're advising about the fact that steps should be taken right away if the tenant wants to enforce their rights. To file a government agency complaint with, for example, HUD, Minnesota Department of Human Rights, or typically a local civil rights agency, generally speaking, the statute of limitations is 1 year from the time of the discrimination. In terms of the Fair Housing Act and the Minnesota Human Rights Act, there is no duty to exhaust. There's no duty to file with a government agency before going to court. But the deadline to file in court is also a deadline that is a relatively short deadline. So that statute of limitations to file in court based under the Minnesota Human Rights Act is 1 year from the time of discrimination. And then for the Fair Housing Act, a person whose request for reasonable accommodation has been denied has 2 years to file an affirmative case based under the Federal Fair Housing Act. And a note about process is that each government agency, HUD, Minnesota Department of Human Rights, has their own forms that individuals may complete to file a complaint. And the general procedure is that once the agency ascertains that the agency has jurisdiction, the agency generally assigns a staff person who will simultaneously investigate the claim of a fair housing violation and conciliate to see if a resolution can be reached. If a resolution can't be reached, the agency will generally issue a decision of probable cause of discrimination or no probable cause. And if there's a decision of probable cause of discrimination, a tenant at that point does have the option to elect, in the case of, I'm speaking specifically of HUD, to elect to federal court. Okay, alrighty, and Department of Justice can lend a hand. But thanks to Rachel for the note about our timing. So let's move ahead.
Sorry, I just meant the scenario. We might have to come back to the scenarios at the end of this portion if we have time. So what would you like me to skip ahead to, Colleen?
I think, thank you so much for letting me know about the time issue. And I think that the audience today is very interested in hearing about the new law.
Okay,
So
we will
can
get to that.
the background. Yep.
All right. I think we're
All
here.
right. That's to me, back to
Okay.
me. And I am so excited to tell you about all the additional rights and responsibilities that owners and tenants have under the new Minnesota statute 504B.113, which if that's what you think I'm going to talk about, you will be sorely disappointed because there are not a lot of new rights and there are not a lot of new requirements under this statute. The differences between the statute and the law, the federal law, are pretty nuanced. But I'm going to go through it with you so you understand what's there. And then we can talk about maybe the small differences that exist. So what it says is that for service and support animals, that a landlord may require a tenant provide supporting documentation for each service or support animal for which a tenant requests a reasonable accommodation, unless the disability or disability-related need for a service or support animal is readily apparent or already known to the landlord. What does that mean? If someone is walking up to a rental office with their guide dog and they are legally blind, you do not need and you should not request documentation for that disability-related need and that service animal. But most disabilities are not that obvious and most animals aren't service animals, they're support animals. So let's look at the next slide, which says that upon a landlord's request, a tenant must provide supporting documentation from a licensed professional confirming the tenant's disability and the relationship between the tenant's disability and the need for the service of support animal. And then it kind of talks about the limited scope of what owner or manager can ask for. And what this does is it says you can ask for confirmation that the tenant has a disability covered by the fair housing laws, but you can't inquire into the specifics, the range, the other medical issues that a tenant might have, or ask or require to look at medical records or ask for a release to look at medical records. So it's limiting the scope to just the verification that the tenant has a disability and that the service animal or the support animal is necessary to treat that person's disability. I saw a question in the chat and I'm gonna answer it now because why not? Which is, how long is this support good for? Hey, the law doesn't say. The law does not say that you have to get a new letter every 12 months. The law does not say if a letter is more than 2 years old, it's not good anymore. I think what it would depend on is the disability related need. Is it something that's obviously still an issue? Or is there a question as to whether the tenant is still suffering from this particular disability? So sorry to not answer the question, but I don't think there is a specific answer to it. And quite frankly, what I would advise is I would say, submit the letter and see what the response is. Because if a landlord says, no, I need more specific, then you can say, no, the statute says you don't need more specific. But if the landlord says, I need more current, you can say, well, the statute doesn't say how current does it have to be. Start the interactive process. And that's how that would kind of shake out. All right, next slide, please. And it says in the statute that a landlord cannot require additional fees. Things like a pet deposit do not apply to service or support animals. So that's a totally different thing. Obviously, owners and managers can require pet deposits, but emotional support animals and service animals are not pets. So that is not a requirement. Sometimes we'll see where owners will say, oh, you have to get insurance, like additional insurance. That is also a fee, a charge deposit, not authorized under the statute or the federal law. So, and then the last part, a tenant is liable for damages. That's the federal law as well. So this isn't a big change to anything in the state law. One of the big changes, though, is who is a licensed professional. This is different than the Fair Housing Act. The Minnesota statute says who a licensed professional is. And it's a doctor or a nurse or a PA or a therapist or a mental health professional or a social worker or a counselor licensed in Minnesota or outside the state if they have a treatment relationship with that professional. And this is probably the crux of the whole new statute. This last little part that says a licensed professional does not include any person who operates primarily to provide certification for a service or support animal. I was not involved in the legislation, and I was not involved in getting this passed. But if you asked me, how did this law get passed? I think it was support for that particular sentence. And I think what it is that owners and managers said, you know, I can't tell if a tenant has a disability because they just go to some online thing and say, yep, I'm disabled, spit out a certificate for me. And I think that advocates for tenants said, all of my disabled clients are getting scammed on some online internet thing where they have to pay hundreds of dollars to get this certification to get their service or support animal verified. So this is where I think the two sides came together and said, neither of us likes this. Let's make it not something that tenants should be rewarded or allowed to do. So to me, that's kind of the crux of this whole thing. Thank you for hanging in there all this time to get to this one sentence at the end of the 34th slide. But if you take one thing away, it's you can't go online and get this under this statute. All right. The next part of the statute talks about what is a service animal. They talk about the federal law. The support animal is defined as an animal that provides emotional support that alleviates one or more identified symptoms or effects of a person's disability. Does not need to be trained to perform a specific disability-related task. If you're looking at this law and trying to determine if your tenant has a disability, if the doctor's letter or the therapist's letter says the tenant has a disability and this support animal alleviates one or more identified symptoms of that disability, I think that under the statute that meets the requirement and that the owners or managers have to approve that animal. So, and then there is a prohibited conduct. Subdivision 4 says a tenant must not directly or indirectly through statements or conduct knowingly misrepresent themselves as a person with a disability or provide fraudulent supporting documentation. And as we know, as lawyers, fraud is a high standard, and that most people trying to do this are really trying to provide what a manager or owner need. But I hope I don't have to litigate this, but if I did, that would be what I would say. It's a high standard to say that there was fraud involved. And then subdivision 5 says if this happens, if someone misrepresents themselves as a person with a disability, an application can be denied or a request for the animal can be denied. All right. And so Colleen and I really wanted to talk about what are the differences between the Fair Housing Act and the Minnesota law, because for a lot of these, we were kind of like, these are really similar. And much of the verbiage in the statute mirrors much of the guidance from HUD about the Federal Fair Housing Act. And even though it's clearly spelled out in the statute, it was pretty clear to all of us who practiced under the Fair Housing Act that that was what HUD would enforce, or what we would enforce if we were enforcing the Fair Housing Act. One difference is the federal Fair Housing Act, and you saw this earlier, the definition of disability says substantially limits a major life activity, and the state statute looks to the Minnesota law, which says materially limits a major life activity. Both the federal and the state statutes say you can request documentation. Both the federal statute and the state statute says additional fees are prohibited. This is kind of probably the biggest difference. The federal law says you have to show reliable information of your disability related need. But the state statute makes that a little more strict and says, you need to show evidence from a licensed professional. Colleen, did you want to add anything there?
I think one thing in my practice is I have had housing providers say it has to come from a doctor. The letter has to come from a doctor. And, one aspect of this law is that it lists other professionals that could provide a letter. And so a tenant can say, actually, this law says I can get a letter from my social worker, for example.
Good point, thanks. The Federal Fair Housing Act doesn't exclude any professionals. It doesn't exclude any category or group of professionals. But the Minnesota law explicitly excludes places that are set up for providing this documentation exclusively. So that is one big difference. And then the last thing is the Fair Housing Act does not mention fraud at all. There is nothing about that in there. But the Minnesota law says a tenant can be denied for fraud. Is there anything else you wanted to add, Colleen?
We just wanted to mention that this statute can be found in the omnibus at the section is Chapter 8, Article 2, Section 10, and then just right after this is you can see the language about the prorated rent statute that's going to be discussed by Sam next.
Thank you for that transition, Colleen. That was beautiful. And I did provide a link to that in the chat for folks if you want to go see the actual language of this. So thank you, Laura. Thank you, Colleen, for that fabulous presentation. And are going to skip ahead quick to Sam. Sam Parmakar is the State Government Director for the University of Minnesota's Student Association. So if you want to add anything else to your intro, Sam, otherwise take it away.
Yeah, thank you so much for the introduction, Rachel. Yep, I am the State Government Director for the Minnesota Student Association. We are the undergraduate student government at the University of Minnesota Twin Cities, representing about 30,000 undergraduate students. And our government and legislative affairs team does advocacy on all levels of government, covering kind of a wide range of issues that affect college students. But of course, housing is one of those really big issues that we deal with. So next slide, please. So today I'm going to be talking about Minnesota's new prorated rent statute, which is a piece of legislation we've been working on for the past 2 years. But before I get to the actual kind of meat of the statute, I want to give a little bit of background and talk about kind of the nexus of this problem. So one thing that folks may be familiar with is that student renters tend to have kind of unique needs compared to the rest of the population and in kind of unique circumstances. So first and foremost, for a lot of student renters, their very first college lease might be the first legal document they actually sign as an adult. A lot of student renters aren't necessarily familiar with the ins and outs of landlord-tenant law. And so I think there's oftentimes a lot of pressure on students who maybe don't understand the full legal implications of the contracts of their lease. So we're really appreciative of organizations like Homeline that do provide that free legal assistance to students and kind of advise them as to what their options are. But a fairly common practice around the University of Minnesota campus and other campuses across the state is a short end lease. So for kind of the most common leases that are present on campuses are 12-month fixed term leases. For the purposes of this presentation, just going to go with the example of a lease that begins on September 1st and lasts 12 months up until the end of August. So these are pretty common for students. Obviously, they kind of sign them each year that they are attending university. And what's become more common over the past 5 to 10 years is the prevalence of a short end lease, where it's still that kind of standard 12-month lease structure, but the lease requires the tenant to move out before the final day of the last month. So I've included here kind of example. Actually, this was one of my old leases from the 2019-2020 school year. You can see that it started on September 1st, but I had to move out on August 21st of the following year. And kind of the reasoning for this is with a lot of these college rental units, they all kind of turn over at the same time around the start of the school year. So a lot of property managers want to have kind of a few extra days to kind of inspect all the units and make sure that they can repair any damage that's done and make sure that those are all ready to go for the new tenants that are going to move in. And so that practice is one that I think is pretty reasonable, especially with the high volume of units that are turning over each year. But what we've been seeing as a trend over the past few years is that period of time at the end of the lease that landlords are kind of taking back to do that maintenance has started to grow longer and longer. So originally it used to be 3 days, 4 days to kind of do that work. In my lease, it was 10 days, but I also hear from a lot of students who are moving out 15 or 20 days before the end of the month for the last month of their lease. And so, you know, that is kind of creates a problem for a lot of students because you probably have another lease that's starting on September 1st, but all of a sudden you maybe have this 2 or 3 week gap you need to cover. And not only do you need to find somewhere to stay, you also need to find somewhere to store all of your furniture and all your belongings. And so that can be a really difficult situation for students, particularly students who are from out of state or international students who maybe don't have, you know, a parent's house that they can go stay in. So that is kind of a factor that puts a lot of pressure on students. And what we've seen is that kind of larger rental companies, particularly companies that are based somewhere else in the country, are the ones that are more likely to have these really early move out dates for their short end leases. And what that does is it puts a lot of pressure on students to kind of re-sign their leases with those companies, because the companies will say, you know, your lease is going to end 2-3 weeks before the end of the month, but if you re-sign with us, you can stay there the entirety of the time. And so they don't then have to worry about finding somewhere to stay, finding somewhere to store their stuff for that 2 or 3 week period. And what we've found is that that creates a bad situation for students who are then kind of pressured into re-signing those leases. But it's also kind of an anti-competitive practice for landlords, particularly if the larger rental companies are using this practice. It kind of creates an unfair advantage for them over the smaller landlords, because they basically have this added pressure that they can put on their student tenants to re-sign their lease rather than having the tenants look at other leasing options. So that's kind of an overview of what the issue is. Like I said, this has really become quite prevalent on the University of Minnesota campus, but we also work with a lot of our peer student governments around the state, and this is a problem that we've been hearing about from Duluth to Rochester to Mankato, so kind of all over. If we could go on to the next slide, please. So in addition to kind of that gap in between leases that's created, the big problem with short end leases tends to be the final month's rent. So in almost every case that we've seen and we've heard about with short end leases, tenants are required to pay a full month's rent for that final month of the lease. And so you can see here, I also included another screenshot from my old lease. It says that the full monthly rent is due each month. That includes that last month where I had to move out 10 days before the end of the month. And so that is a practice that we feel is unfair. You know, if a student or a tenant is only able to occupy a unit for a portion of the month, then they really should only be paying a portion of the rent for that month. So we most commonly see this with the short end leases that kind of end midway through August. But another kind of less common example of this is a lease that maybe starts before September 1st, so maybe starts at the end of August, and then they are moving out at the beginning of the next August. And so in that situation, the short end month is kind of front-ended on the lease, but you know, we're still wanting to make sure that tenants are not having to pay a full month's rent for that either. If we could go on the next slide, thank you. So I'll talk a little bit about the legislative process for developing this piece of legislation. So originally, we kind of brought this forward in the 2020 legislative session, kind of right before the pandemic happened. Representative Khalid Hur and Senator Carrie Diedzik, the latter of which represents the university, they kind of brought this forward and helped us develop this language. We also worked with the housing attorneys at University Student Legal Services, which are the free attorneys at the University of Minnesota that students can use. They provide really valuable services to student tenants in particular. So they kind of helped us come up with the language, and the housing attorneys at Homeline kind of helped us refine it and make it better. So we were really appreciative of that. And we initially had a hearing in the House back in 2020 in the Housing Committee that went pretty well, but unfortunately COVID kind of put that on pause. So this year we kind of were back with this effort, and unfortunately weren't able to get a hearing, but we did work with the chair of the House Housing Committee to get this included in the large housing omnibus budget bill that they passed before the end of session. And we really wanted to work hard to kind of build a coalition of support for this bill. So not only did we work with other students around the state, but you know, we got support from members of the legislature from both parties. We also kind of consulted with the Minnesota Multi-Housing Association on this language to make sure that they didn't feel it was too unreasonable. They ended up not having really any opposition to the language. They felt it was fair. So we felt that the language in the bill really struck a fair balance between the rights of landlords and the rights of tenants. And so ultimately this was included in the bill that the House passed. And then when that bill went to kind of the conference committee and they negotiated it with the Senate Housing Committee, ended up in the final agreement that was then passed by the legislature and signed into law by the governor. So in terms of the actual text of the bill, here is the statute, which is section 504B.116, and that's going to be effective for leases beginning on or after September 1st of this year, so a little less than a month. So it says that when the lease ends on a date that's not the end of the month, the amount of rent owed for the final month must be prorated, and also includes kind of a non-waiver clause saying that that provision can't really be waived in the agreement. And also kind of includes a formula for calculating what the amount of that proration will be. And yeah, next slide, please. So yeah, basically kind of breaking down that legal language. So right, like if a lease ends before the final day of the month, that the rent for that month needs to be prorated. It does include that provision for calculating the rent. So that's kind of calculated by taking the monthly rent and figuring out what the daily average for that would be, and then multiplying that daily average by the amount of days that the tenant is actually allowed to occupy the unit for that month. So for the sake of simplicity, I kind of use the example of a 30-day month with a lease that says the tenant has to move out on the 20th. So they're there for 2/3 of the month. And if the rent was $900, they would then only have to pay 2/3 of that rent, being $600. So, and then additionally with that non-waiver language, basically saying that a lease cannot include any provision that would waive the requirements under this statute. So it's binding regardless of whatever the lease says. And so that's kind of the overview of that statute. Again, that's going into effect September 1st. And we're hoping that that will make a big impact for tenants, particularly student tenants who will potentially be being saved hundreds of dollars in the kind of the last month of their lease by having that amount prorated. But this is kind of part of a larger agenda of student tenant protections that our organization has been pushing at the legislature over the past few years. So back in 2019, we worked on a piece of legislation to amend section 504B.111 to say that when a lease is signed, that lease needs to include a specific unit number. Because one thing we were seeing, again, on college campuses across the state is students would kind of go on a tour, they'd like see this unit and they'd be like, great, okay, I want to sign this lease. I really like this apartment. And they'd sign a lease for say like a 4-bedroom, 2-bathroom. And while they'd still get a 4-bedroom, 2-bathroom on their move-in date, they find out that they're actually not in the unit that they thought they were going to be in. And so we thought that just for transparency's sake, it's really important to specify on the lease as it's signed what unit a tenant is actually moving into. And then this year, kind of alongside our efforts to get this prorated rent statute passed, we also were working on a provision kind of regulating early renewal of leases. So again, with these 12-month leases, one thing that's really common is a tenant might move in kind of September 1st. And again, these large national rental companies are kind of the main perpetrators of this, but they would basically put a lot of pressure on the tenant to say, you need to renew your lease for the next 12-month period by October 1st or by November 1st of this year. Otherwise, we're going to start showing your unit to other prospective tenants, and we can't guarantee that you're going to be allowed to stay here. And that was something that we found was putting a lot of pressure on student tenants to re-sign their leases really early on in their school year, 1 to 2 months into their current lease. And that created kind of a litany of problems where, you might find out 6 months later that you actually really don't get along with your roommate, but you've already signed another lease with them. Or you might decide you want to study abroad, but you're already locked into a lease. And so that was something that was creating quite a bit of problems for student renters. And so the language in the other piece of legislation we proposed basically said that for longer duration leases of 10 months or longer, that a landlord could not require a tenant to renew a lease within the first 4 months of occupying that unit. So kind of creating a bit of a grace period where tenants would have a period to decide whether or not they really wanted to stay in that unit and whether or not they wanted to live with some other people. So that was included in the housing omnibus bill as well, but ultimately was not included in the negotiated bill with the Senate, but that is kind of a provision we're looking at bringing back next year, and is again another provision we're working on collaborating with student renters as well as small landlords on. So that is kind of an overview of that statute that's going into effect September 1st, and I think that is all I have right now.
That was fantastic, Sam. Thank you so much. Yeah, so that one, just to be very clear, so the guidelines around emotional support animals, that went into effect on August 1st. This one that Sam was just talking about goes into effect on September 1st. So I see it by my clock that it is 2:54. So we've got about 6 minutes for our normal Q&A portion. Samuel and I are able to stay a little bit past 3 to answer some of the more general landlord-tenant questions. But I thought I would ask, looks like most of the questions that have come in are in regards to emotional support animals and along those lines. So Laura, Colleen, would you be willing to answer those questions first? And then Samuel and I, if we're past 3 at that point, would be happy to stay on. And at the very least, I understand that folks can't necessarily stay past 3. This is what we scheduled for, but we will be recording this session. So if you need to go back and listen to the last 10 minutes or so of whatever it is that we are recording, that is an option for you. I'll put this back up on the screen real quick. Our upcoming webinars for next 2 weeks. If you're interested, you can go to our website and register for them. Okay, so hi, Laura. So I'm going to go through, none of our pre-submitted questions were in regards to what you both covered. But we did get a couple in our Q&A, as you referenced earlier. So I'm just going to go through those quickly. I think some of them were already answered, but for Kevin is asking for emotional support animals. This was the doctor that wouldn't provide a letter for their client, or a new letter. You had said earlier that those don't expire, at least under the law, correct?
Right. There is no guidance on if a letter is too old or not too old, but it is a reasonable accommodation. So we look at what's reasonable and what makes sense. I think it's reasonable to understand a person with a disability would have a continuing disability unless something really like miraculous happened to to solve the issue. So I think not granting an accommodation because a doctor's letter is old would put a housing provider in some legal jeopardy under the Fair Housing Act and the new law.
Okay, Kimberly is a landlord, and they're wondering, so 504B.113 in subdivision 2B, the way they're reading it, they've got some questions about the verbiage. It says that the landlord can request a tenant to provide documentation confirming a tenant's disability and the relationships as it relates to the need for this animal, but also then goes on to state that it requires that this can't require to disclose the physical or mental disability. So Kimberly's wondering, how do we ensure it is valid reason without getting in trouble with the ADA?
Yeah, so it's not the ADA, it's the Fair Housing Act. So just remember that. And I think the idea is that it's that kind of fine line between what you can require and what can't be required, and what's actually valid and what's not valid. And I guess, you know, if the doctor says this tenant has a mental disability that substantially limits a major life activity, can the landlord ask what that disability is? I would say probably not. I mean, you can generally ask, but is it bipolar with psychotic features? What kind of psychotic features? I mean, those are impermissible. Those are clearly impermissible to dig into somebody's, you know, personal medical diagnosis. But if the doctor says this is the diagnosis, or the diagnosis is mental disability, I think a housing provider could get in trouble for trying to say, no, you have to tell us what kind and what kind of features it has and what their prognosis is and how it works. Those are the impermissible inquiries. On the other hand, you know, I've seen a bunch of letters and they look really goofbar. They look kind of crazy because we know doctors and they're like, writing letters isn't their forte. They can't bill for it, and they don't always have all of the information that a housing provider would consider relevant for this kind of a thing. So sometimes they look really odd, and I think it's fine to verify that this person is a medical provider, that this person is someone that's covered by the statute, that this person works at the place where they say they worked. I mean, I see these sometimes without letterhead, just on plain sheets of paper, and it is really what a doctor wrote. It's just they don't, you know, they don't have a person that, you know, they dictate these to and they spit it out. They're, you know, running from room to room to do patient work. So, but if you are a housing provider and you say, I'm not going to accept this letter without doing any kind of due diligence to say, you know, this is the doctor's signature, this person works at this clinic or whatever, I think you could get in trouble under the fair housing laws.
Thank you. There's one more question that falls under this umbrella, I think for either one of you. It is 3 o'clock, so you know, but Anonymous is wondering, does the protected class of status of public assistance apply to Section 8 recipients?
Okay, well, Brand, that one's yours.
Okay, so the definition of status with respect to public assistance under the Minnesota Human Rights Act does say in the language that it applies to rent subsidies. However, a few years back, the Minnesota Court of Appeals had a case where they issued a decision stating that they did not find that it mandated participation in the Section 8 program. And following that, the city of Minneapolis adopted new language in its civil rights ordinance regarding protections against discrimination based on rent subsidies, and that is currently still in ongoing litigation.
Great. Thank you very much for that. And yeah, so I want to say thank you once again to all 3 of our guest speakers today. It's been very informative, and I really appreciate it. Feel free to stick around if you want to chime in on any of the other questions that we have that may not be specifically about the topics that you were talking about, but Samuel and I are going to get through as many of these as we can as well. And again, so first off, let's see. Anonymous is asking, and I'm just going through our list here. Anonymous is a landlord, and they want to know, how do we know if we can proceed with evictions allowed under an off-ramp when the high COVID cases can change day to day? That's an excellent question. And so I'm going to jump in on that one, Samuel, if you have anything, or if anyone else has something to kind of add. The CDC, at least with the CDC moratorium, those cases are calculated on a week-to-week basis. But if the concern with, our off-ramp is like, obviously the Delta variant exists and is definitely, that's the purpose of like why the CDC re-upped its moratorium. So as those cases increase in Minnesota, is there a possibility that we may go back into some sort of peacetime emergency state or have some sort of moratorium in place? I cannot tell you one way or the other if that is going to happen or not. As we've been saying throughout most of these webinars, and probably will continue to say through most of this, the law is changing what feels like day to day, but certainly almost week to week. And so we're doing what we can with interpretation of what we've been given, but a lot of the times the answer is this is our best guess, and we just we got to deal with this is the law as we think it stands today. Whether that's going to change tomorrow or not is yet to be seen. Samuel, do you have any other thoughts about that?
No, I think it's mostly that's related to the CDC, which you know a lot better than I do. It doesn't, whether there are high COVID cases, it doesn't impact the state session law or anything like that.
Yep. Okay, I'm going to go back to our pre-submitted questions quickly. We had most of these were about the CDC moratorium, which I will just go through. I think I answered most of them during my little chunk of the presentation, but Christine is a landlord and wants to know if the feds reinstate the eviction moratorium, which law is controlling Minnesota phase out or feds? And we kind of went into the timeline of Minnesota's phase out is broader than the CDC. And so the CDC moratorium explicitly states that if a state rule or law offers more protection, then that is the one that will be in effect. Teresa is a landlord and just want to know, what does the new CDC extension mean for Minnesota? Again, not a whole heck of a lot right now. Specifically in Hennepin, Ramsey counties, same thing. The only time it might come into play is starting on September 12th, when folks who are ineligible for the emergency rental assistance programs that are stipulated under the Minnesota phase-out law, those evictions, if they're behind on rent, can start on September 12th. But if those folks are eligible for other government assistance programs, then they may be protected under the CDC moratorium. Okay, and so Gutam is, I assume, a landlord. They're buying a duplex and which needs a lot of repair. It's going to be impossible to do those repairs while the tenants are living there. What are my options?
Is this one for me, Rachel?
Yes. Why don't
Okay.
you? I'm going to take a break for a second.
Yeah, no. So, we do want to be careful. We're not giving legal advice to anyone. And this is so specific. I just want to make that clear. You would really need to talk with an attorney to know exactly what is the case, because there are many different facts that could change this. But very generally, I can say that nothing that you said as you said it affects the eviction statute in any way. And so all of the eviction requirements, or I should say, the various things that are allowed under the different phases are what they are. And, assuming it wasn't the tenant who caused those damages, no notice to vacate would be valid. At least from our perspective, no notice to vacate would be valid. And you wouldn't be able to evict the tenant either, obviously, for repairs that weren't their issue. Again, this is less legal advice, more just a general observation, but these are things that should definitely be considered when buying and maybe affect how you or when you buy houses. And if you haven't talked with an attorney to go, exactly what this would mean for your bottom line, that would be a good thing to cover it. It would be in many ways a lot like buying a house and then suddenly discovering that there were, massive issues with the sewer or something like that that needed to be fixed. So you gotta take this type of thing into account. But in general, nothing that was mentioned here actually affects or would change things under the current eviction moratorium law.
Thank you. Anonymous wants to know, when will non-payment cases that were filed and served pre-COVID, so back in February, March of 2020, be heard?
I don't know if you know differently or more, Rachel. We've heard different things from different courts at different times, but it is mostly up to the courts and what they decide to do. Months ago, back when, it was like November, October of last year, and the courts thought, they might expire. They said that they were planning on taking them, essentially as soon as it expired, but I don't know if that's changed at this point.
Yeah, my understanding is the same as yours. It's on a basically district by district basis of how they're handling them. Okay, so Amy would like to know, can we request proof that the tenant applied for emergency rental assistance?
Yes, it's somewhat limited. There's not a whole lot of proof that the tenants can provide, but the statute does require the tenants to show the landlord that they've applied. And for like Rent Help MN, they're sending the tenants written confirmation, I think generally by email, that the application has gone through. So the tenant should have something that they should be providing, but it's not very much.
Yeah, I know sometimes when you're finished applying and you've been approved for applying or whatever, I think the Rent Help MN process encourages the tenant to screenshot essentially or print that confirmation screen as well. All right, Meg would like to know, how do non-payment of charges unrelated to rent factor in here? For example, if a tenant owes money for a repair, what action can a landlord take against the client at this time?
This is a good question. We got asked a very similar one last week. That was very specific to utilities, but this is a little bit broader. The first thing would be to look at whether or not any of these fees are rolled into rent under the lease. Especially when you're talking about repairs, you do occasionally see that where it says if the tenant owes money for a repair, that money is counted as rent. If the lease itself says that it's rent, then it's probably rent, and the landlord has to follow all of the the eviction guidelines that are in place right now. There's also some arguments, although for repairs it's a little bit less clear than for utilities, that any debt owed and that is money, you can argue the tenant can redeem it, although again, that's a lot more clear if the tenant is not paying a utility bill than it is if the tenant owes money for a repair. Practically, if a tenant were asking me this question, my concern for the tenant would be that if they owed money for a repair, they also damaged, that means they damaged the property. And if they damage the property, that could be either a material lease breach or possibly substantial damage to the property would fit under the initial categories that you could file evictions for way back on June 30th. With the specific thing related to repairs, there might be some other issues there, depending upon what exactly was wrong.
Sorry, I was laughing because you said way back on June 30th, and that was, just over a month ago, but it does feel like a lifetime in some cases. So yeah, COVID timelines are weird things. Kevin wants to know, how might this affect someone's credit once it's determined rent is due? I'm not quite certain what this Kevin was referring to, but just if a tenant has past due rent, how does that affect their credit? It's a little outside landlord-tenant law, but do you have any insight into that, Samuel?
Not really. To be honest, I don't know a whole lot about how credit works, at least like on a technical level. Obviously, what sort of everyone knows, that if you owe money and it gets reported, that can affect your credit. But, if a landlord doesn't report it, I don't think it shows up at all. If they do report it, it could affect it negatively. And then once it's paid, it's a paid debt. If the landlord actually files and wins a court case and they get a judgment, like Rachel, you and I had discussed, then that obviously could have a very negative effect on the tenant's credit. But if it's just a debt owed, then I think it is going to be treated like most other debts. And if it gets paid, it's going to be treated like most other debts that are paid.
Okay, perfect. All right, we're getting there. We've got 3 more questions, it looks like. So Teresa is a housing advocate who were previously experiencing homelessness. And just wondering, so starting August 14th, are those who are staying in Hennepin County high transmission protected from a lease termination if they have outstanding rent and are ineligible for COVID-19 rental assistance? Or does the CDC moratorium only protect from landlords filing an eviction? So under the CDC moratorium, yes, the CDC moratorium is specifically for evictions. It doesn't have any language about lease terminations or non-renewals. So there are, so it's, if coming on, so August 14th, that that was the timeline for, sorry, I'm going to go back to our timeline really quick. Oh, that's too far back. Never mind. That's like 50 slides away. So basically, yeah, in the phase out, there are different restrictions on lease terminations and renewals versus evictions, but the CDC moratorium is only protecting against an eviction action. Teresa also wants to know, does the lease termination mean that folks need to move out of their apartment right away, or does that only take effect after eviction? Sammy, you want to take that part?
Sure. Yeah. So, I mean, I think what the question is asking there, and I might be wrong, is just, how do notices to vacate work generally? And, a lease termination or notice to vacate would simply terminate the lease. The lease itself, if it was a valid notice, that the tenant should move out. If they don't move out, they become a holdover tenant. And at that point, the landlord would file an eviction for holding over after a valid notice to vacate. And then you have the question of what evictions, when can those evictions be filed? And it's a little bit of a gray area. We don't even have complete confidence on an answer to that question yet.
Fair enough. All right, I'm going to answer Molly's question real quick. So Molly just want to know when the recording is going to be available. So this should be available in the next week or so. Basically, I'll get the recording and we'll need to do a little bit of splicing, editing at the beginning and end. So hopefully within the next week or so. All right, and then finally, Dave wants to know if we're aware of any laws or regulations that would prohibit a landlord from requiring rent only to be paid online. Does anything require landlords to provide an alternative way to pay?
I assume this one is for me. There are reasonable accommodation requests, of course, that could be at issue here. You also run into additional trouble if paying online costs the tenant extra and it's the only way to pay. For example, if the only way the tenant can pay is online, but then there's a 5% surcharge or something like that, then you might have issues because that's basically something that isn't written into the contract. The landlord is then trying to make the tenant pay. That said, we're not aware of anything that would prevent it if all of the terms are upfront and it doesn't impact any specific disabilities. People have mixed feelings about this, myself included, and I'm not sure that it's always a great thing, although I actually pay pretty much all my bills online if I can. I understand why some people don't want to. But again, if it doesn't impact any disabilities and it is fully explained in the lease itself, because if it's not in the lease, I maybe didn't say that clear enough, but if it's not in the lease, you can't require a mid-lease or something like that. But if it's fully explained in the lease itself and there's not hidden charges that are against the lease, then it is probably allowed.
Mm-hmm. Absolutely. All right, and we made it through all the questions. So well done. And thank you everyone who stuck around with us, gave us an extra 16 minutes or so. And again, thank you for coming. And if you have any interest in our upcoming webinars, please register for those. They are going to be August 18th and 25th. They will be also being applied for 1.5 CLE credits for those of you who need those sorts of things. And feel free to look into our website. And if you have any questions, feel free, if you're a tenant, contact us on our hotline. And again, thank you so much. You have a wonderful rest of your day, everybody. Bye-bye.